again. Upon filing an accusatory instrument, an information, a simplified information, a prosecutor's information, a misdemeanor complaint, the defendant must be arraigned, and the defendant must appear personally except for
Simplified information.
Simplified information where the procedure is provided and would dispense with arraignment or personal appearance or a summons or appearance ticket. The court may permit the defendant to appear by counsel.
Okay. Can you say that one more time a little slower? Just the
Yep. I'll say the whole thing just a little slower.
Okay.
170.10. It's upon the filing of an accusatory instrument, and those accusatory instruments are an information, a simplified information, a prosecutor's information, or a misdemeanor complaint. The defendant must be arraigned, and the defendant must appear personally, except for what?
A simplified information.
Right, where the procedure is provided and would dispense with arraignment or personal appearance.
Or defendant received a summons or appearance ticket, the court may allow him to appear by counsel.
Perfect.
Okay.
2, if the defendant appears without counsel at arraignment, he has the right to 1, adjourn to get counsel, 2, communicate for free by letter or phone or to obtain counsel, and 3, have counsel assigned by the court except for blank or blank only.
A traffic infraction or infractions only.
Yes. 3, where blank and blank is charged, the defendant must be informed that a judgment of conviction would subject the defendant to sentence, therefore render his license to drive and registration subject to suspension and revocation.
True.
Well, I was looking for the blank and blank.
Oh.
Where traffic infractions and misdemeanors
misdemeanors relating to traffic. Okay.
Those traffic, I'll read it one more time with the complete sentence.
Okay.
Where traffic infractions and misdemeanors relating to traffic infractions or relating to traffic is charged, the defendant must be informed that the judgment of conviction would subject the defendant's sentence, therefore render his license to drive and registration subject to suspension or revocation. A plea of guilty constitutes what?
Conviction.
Right. Blank defendant has the right to a supporting supporting disposition filed. Deposition filed.
A defendant charged in a simplified information has the right to a supporting deposition.
A simplified traffic information, correct. Blank defendant may not be prosecuted unless he consents, and if he does not consent, the blank will have to be replaced and superseded by a what?
A defendant prosecuted by a misdemeanor complaint must consent to be prosecuted by a misdemeanor complaint. If he does not consent, the misdemeanor complaint must be replaced by an information.
Perfect. Blank and blank. If the defendant wants to proceed without counsel, the court must permit him to do so.
Traffic infractions or infractions only.
Right. You're good. I don't remember these questions. Upon arraignment, unless court intends to make final disposition, must provide what?
A securing order.
Right. And Article 70 securing order can do what?
Commit to the... No. It can release on bail, ROR, and that's it.
Right.
Fixed bail or release on recognizance. That's
right.
It.
Set bail for future appearances or ROR. Article 170, securing order. If the defendant appears by counsel, the court must... I remember doing this question with...
release on recognizance.
Right. A local criminal court may not at arraignment or within blank of arraignment on a simplified traffic information charging a violation accept a plea of guilty to the violation of any VTL or any other traffic infraction, violation or misdemeanor where the court is aware that such violation was charged pursuant to an accident involving death or serious physical injury.
Unless 30 days have passed.
Yes. So the criminal court may not at arraignment or within 30 days of arraignment accept a plea of guilty where anybody is involved in an accident that involved death, right?
Yep.
Okay. Next question. Motion to dismiss. Article 170. Motion to dismiss an information, a simplified information, a prosecutor's information, a misdemeanor complaint. After arraignment, the court may, upon motion of blank, dismiss the instrument.
Defendant.
a count, right, upon the grounds, and there are 7 grounds.
All right, let's see how many I could get.
Go ahead.
Insufficient on its face.
I don't see insufficient as a word in there.
Defective.
Yeah, that's right. Defective. Okay.
Defective.
Right.
Barred by previous prosecution.
Yes.
Immunity.
Yes.
You know what? I don't remember the other one, so just say them.
Untimely.
Untimely.
The defendant denied a right to a speedy trial.
Oh.
Some jurisdictional or legal impediment, and furtherance of justice.
Furtherance of justice. Okay, so say all 7 of them in a row.
Okay, I just was going to say that. Would you like me to read all 7 of them?
Yes.
Okay, hold on. I had to get some candy.
Oh.
All right. Motion to dismiss any of those accusatory instruments in the local criminal court, the information, the simplified information, the prosecutor's information, or the misdemeanor complaint. After the arraignment, the court may, upon motion of the defendant, dismiss the instrument or any count upon the grounds that it's defective, immunity, prosecution barred by reason of previous conviction, untimely, defendant denied a right to a speedy trial, some jurisdictional or legal impediment, and furtherance of justice.
Okay, let me see if I can do it again from memory now. All of them.
Because I'm getting my,
Okay, so the first one was defective. Legal impediment. Jurisdictional or legal impediment.
Mm-hmm. Yep.
Furtherance of justice.
Right.
Double jeopardy.
Right.
Denied right to speedy trial.
Yes.
Immunity.
One more. Tick tock, tick tock.
Oh, I don't know.
Untimely. That's
my God. Untimely. All right.
That's why we're saying tick tock, tick tock.
Oh man, I'm just thinking you told me to hurry up.
Yeah, time is running out. Next question.
Okay.
Motion to dismiss should be made prior to blank or blank. And
No. It's commencement of trial or plea of guilty.
Let's see if the answer is C. I don't even know what the damn answer is. 13. Yes. So motion to dismiss should be made prior to the commencement of the trial or the entry of the plea of guilty. ACOD in Article 170. Oh, I'm supposed to be making checks on these questions. I need to make, did we do anything that I want? Never mind. Let's just continue. ACOD, information, simplified information, prosecutor's information, misdemeanor complaint, blank and blank. The court may order Oh, we just did that question. It's just a little different, though. Upon arraignment or after or before the plea of guilty. ACOD, upon motion of the people or defendant with consent of who?
Defendant.
Of a party.
Oh, okay. Damn it.
Or upon motion of the court with consent of both parties.
Both parties.
ACOD is an adjournment with or without a date?
Without.
Right. Upon issuing ACOD, court must order the defendant?
Release on recognizance.
Right. Upon application of the people within blank or blank for family or marijuana of issuance of the ACOD, the court may restore the case to the calendar upon determination that dismissal would not be in the furtherance of justice. Within how long? So this is
6 months for everything else, 1 year for family offense or marijuana.
But isn't there another 6 months for something else?
There's 6 months in JD.
6 months for JD and 6 months for what? One other one, isn't there?
Hold on, let me look at my chart here. Okay, so ACD for juvenile delinquency is 6 months. PINS is 6 months. So Article 7, PINS 6 months. Child protective 1 year.
So all of them in family court are pretty much 6 months except for child protective.
Yep. And Article 8 is 1 year.
Everything's 1 year. Article 8 and child protective is 1 year?
Yep.
Everything else is 6.
Yep.
And criminal
And
170.
Article 8 could also be 2 years. It could be
Wait, so
one.
the one we just did in criminal is how long?
That's 6 months or 1 year if it's marijuana or family offense.
Okay, but it's normally 6 months.
Normally
now.
6 months.
Okay, got it. Oh my god, this shit's so fucking confusing. Next question. Let me plug my iPhone. Hold on, put the plug in. All right, we're on a roll, man.
I know.
Okay. I was up to this question. Okay, so it's 6 months, 1 year for family or marijuana. In the case, if the case is not restored in 6 months or 1 year, the accusatory instrument is deemed what by the court?
Dismissed, and the prosecution is a nullity.
Great. In conjunction with ACOD, the court may issue a what?
Temporary order of protection.
Right. The court may grant ACOD on conditions of the defendant is under how old? Charged with a misdemeanor with alcohol.
21.
21, right? Yep.
Yeah.
Upon this, a charge of alcohol. Let me just read it.
Yeah, read the whole thing.
The court may grant ACOD on condition of a defendant is under 21 years old, charged with a misdemeanor with alcohol involved or a violation in the alcohol and beverage law, required the defendant to attend an alcohol awareness program, the mental hygiene law. Okay, upon dismissal of the accusatory instrument, the arrest and prosecution shall be deemed
a nullity.
Right. ACOD marijuana, information, prosecutor's information, misdemeanor complaint, where the only count charges a violation of marijuana. It's before the commencement of trial and entry of plea of guilty upon motion of who?
District attorney or defendant?
I think it's only the defendant. Yeah, the defendant. May order ACOD upon the finding of ACOD would be necessary and appropriate. They may dismiss the accusatory instrument in furtherance of justice. So that was marijuana and ACOD, and it's upon motion of the respondent only. The court may not order ACOD or dismiss an accusatory instrument if, and it's all of these that I'm going to list, okay?
Okay.
They may not order ACOD or dismiss the accusatory instrument if, 1, the defendant has previously been granted an ACOD. 2, the defendant has previously been granted a dismissal. 3, the defendant has previously been convicted of offenses involving controlled substances. 4, the defendant has previously been convicted of a crime and the DA does not consent. And 5, the defendant has previously been adjudicated a youthful offender involving controlled substances and the DA does not agree. And at any time prior to the dismissal, the court may modify, reduce, or extend the term of the adjournment. That's right, right? Modify, reduce, or extend.
This is all for marijuana, right?
That's what I'm reading in that section.
Yeah. It's all for marijuana. Okay.
Yes. So 25 is yes. And then the total limit of the adjournment shall not exceed?
1 year.
Yeah, I have 12 months, but yeah, 1 year, whatever. Defendant whom blank is pending is not required to enter a plea.
Misdemeanor complaint.
Right. And it has to be replaced with?
An information.
And if a misdemeanor complaint is supplemented by a blank, such instrument...
Supporting deposition.
And it shall constitute a valid...
Information.
Right. Supporting deposition and reporting... 2 more questions. 1 more question on this test.
All right, so we're definitely going to keep going because this video is only 13 minutes long.
Yeah, and that was 170. Let's keep going. 1 more question. Defendant arraigned on a misdemeanor complaint may waive prosecution of information and consent to be prosecuted upon the misdemeanor complaint. In such case, the defendant must be required to enter the plea to the misdemeanor complaint when?
I don't know.
Upon the date of the waiver.
Oh, okay.
Okay? That was 170. Moving on. 180. Oh, and this is going to be fast, too. This is a short one.
Okay.
Well, I think it's short. Upon arraignment on a felony complaint, court must, A, immediately inform him of his charges. B, inform him the primary purpose of the proceeding upon the felony complaint.
Is to determine whether he'll be held for the action of the grand jury.
C, furnish him with a copy of the felony complaint. Yes, all of the above. 2, defendant has the right to a blank hearing upon the issue of whether there's sufficient evidence. Correct. A prompt hearing to see if there's sufficient evidence to hold him for the action of the grand jury. 3, defendant has the right to counsel at arraignment and every subsequent stage of the action. If he appears without counsel, he has the right to 1, adjourn to get counsel. 2, communicate for free by letter or phone to get counsel. 3, have counsel assigned by the court if financially unable to do so. That's all of the above.
Yep.
4, if a defendant decides to proceed without counsel, the court must permit him, if it is satisfied such decision is with knowledge of significance, but if it is not satisfied, it may not proceed until the defendant is provided with a counsel, and if he proceeds without counsel, he waives his rights. True or false?
False. He always has the right.
Right. 5, upon arraignment of a felony complaint, unless the court intends to dismiss the felony complaint, it must issue a securing order. The securing order on a felony complaint can do what?
Fix bail, release on recognizance, or commit to the custody of the sheriff.
Correct. 6, if the defendant waives hearing on a felony complaint, the court must what?
Order he is held for action of grand jury.
Or
dispose of the felony complaint pursuant to this article.
It's actually or make an inquiry for the purpose of determining whether the felony complaint should be dismissed.
Oh, dismissed. Okay, I thought it was disposed of. Okay.
Well, that's it. I think you would have got it in the question. If the defendant waives hearing and the court orders him held for the action of the grand jury, the court must promptly transmit to the superior court 1, the order. 2, the felony complaint. 3, supporting depositions. And 4, all other pertinent documents. 8, if the defendant waives hearing and the court makes an inquiry for the purpose of determining whether the felony complaint should be dismissed and blank be filed in lieu of. What can be filed in lieu of the felony complaint?
An prosecutor's information, or misdemeanor complaint.
A prosecutor's information, or a misdemeanor complaint, correct. That's in lieu of the felony complaint. And that's if they don't hold them for the action of the grand jury, right?
Yep.
Where the local criminal court held the defendant for the action of the grand jury at any time before submitted to the grand jury, the blank may apply ex parte to appropriate superior court for an order directing felony complaint, and all papers be returned to the criminal court for reconsideration. I think it's the district.
Me too. I think it's the DA.
It is the DA. 10, superior courts may issue an order of reconsideration if it is satisfied that the felony complaint is A, defective, B, required in the interest of justice, C, is necessary because the defendant looks innocent.
A, B, and D. A and B.
Right. Wait. So once again, the superior court may issue the order for reconsideration and not hold them for the action of the grand jury and send the papers back to the local criminal court if it's satisfied that it's defective or required in the interest of justice. Right?
Yep.
And 11, if the court is satisfied that there is reasonable cause to believe that the defendant committed offenses other than felonies, it may order reductions. If not reasonable cause he committed a felony in addition to the non-felony, the court may order the reduction to the non-felony offense. If reasonable cause to believe he committed a felony in addition to the felony, the court may order reductions to the non-felony offense if A, it's in the interest of justice, B, the defendant consents, and C, the district attorney consents. It's only A and C, in the interest of justice and the district attorney consents.
Okay, can you read that with just the correct answers in it?
Yes, I'm going to do that. So if the court is satisfied that there is reasonable cause to believe that the defendant committed offenses other than felonies, it may order the reduction. So it may order them if they have reasonable cause to believe that he did things other than felonies. But if they do not have reasonable cause to believe he committed a felony, so they don't think he caused the felony, he committed a felony, it may order the reduction to the non-felony if he has reasonable cause Wait, I'm sorry. If not reasonable cause to believe he committed a felony in addition to the non-felony, the court may order the reduction to the non-felony. If reasonable cause to believe he did commit the felony, the court may order the reduction, but only if it's in the interest of justice and the district attorney's consents. So they're talking about they're going to reduce they're going to reduce it if there's no felony, and if there is a felony, they can still reduce it, but the DA has to consent and it has to be in the interest of justice.
Okay.
That's what it says. You get it?
Yeah, DA has to consent.
DA has to consent if he did do the felony. That's what it says.
If there's reasonable cause to believe he did the felony, DA's got to consent.
Right. Let me take a sip of my water because from talking so much, my throat is.
Okay. Do we have a lot left to go on 180?
No. Well,
Good.
I'm reading fast, so I think it's good, right?
Yeah.
And it's good. You're yelling at the answers, and we're seeing if we don't remember anything. This is perfect.
I know.
Well, I don't remember a lot of this stuff, but I'm just going through the motions, hoping that if I see another test, I remember it.
Well, when you do your videos, I'll upload them, and then, like, they'll be both. They'll be our video together and your videos.
I'm going to spend more time on the screws listening to videos than I do when I'm home.
Yeah.
All right. When a charge is reduced from a felony to a non-felony by replacing it, and they would replace it with what? An information, a prosecutor's information, or a misdemeanor
complaint.
Right? If factual allegations and supporting depositions are legally sufficient, the court may direct the DA to file what?
A prosecutor's information.
Right. Or request the complainant to file what?
An information.
Or they can convert it themselves into what?
A misdemeanor complaint.
No, an information.
Oh, an information. Okay.
And then the last one is, if factual allegations of the felony complaint, though provide reasonable cause to believe the defendant committed a misdemeanor, are not legally sufficient to support the misdemeanor, the court may reduce the felony complaint to?
A misdemeanor complaint.
Yeah, and that's tricky.
Yeah,
because the
that's
law
why I got
says
confused.
that they don't have legal sufficient to support it, but yet you can file the misdemeanor complaint. Right?
Yeah, yeah. Can you read just the two with the information and the misdemeanor complaint?
Sure, I'll just read the whole thing. When a charge is reduced from a felony to a non-felony offense by replacing it, if factual allegations supporting are legally sufficient, the court may either direct the DA file a prosecutor's information, they can request that the complainant file an information, they can convert it into an information, or if factual allegations in the felony complaint, though provide reasonable cause to believe the defendant committed a misdemeanor, are not legally sufficient to support misdemeanor, the court may reduce the felony complaint to the misdemeanor complaint.
Okay.
It sounds weird.
I know,
but the next one I'm just going to read fast. It's the felony complaint hearing, the order.
Yeah, read that.
The district attorney must conduct the hearing. The defendant may be present. The court must read the felony complaint to the defendant unless waived. Each witness must testify under oath. The people must call and examine witnesses and offer evidence. The defendant may testify in his own behalf. Each witness and defendant may be cross-examined. The court may permit the defendant to call, I think it's may, right?
Yeah, it's different in juvenile delinquency.
Let me just look. Seven is...
It's a may.
It's may.
It's may.
Okay,
it's a must in juvenile.
Okay, the court may permit the defendant to call and examine witnesses and evidence, and only non-hearsay evidence is admissible to demonstrate reasonable cause. Next, I didn't finish. The court must or may exclude the public.
May.
And the hearing should be completed at one session in the interest of justice. It may be adjourned, but in the absence of showing good cause, no adjournment may be for more than...
I think it's either one day or one court day.
It's 1 day.
1 day, okay.
At the conclusion of the hearing, court must dispose felony complaint as follows. So we're talking about the conclusion of the hearing.
All right, let me see if I can do this. If there's reasonable cause to believe he committed a felony, any felony, court must order he's held for action of the grand jury.
Right.
If there's not reasonable cause to believe he committed a felony, but there is reasonable cause to believe he committed some offense other than a felony, the court may dispose of the felony complaint by
Okay, go ahead.
by either reducing it and making notations on the title of the instrument and everything to a misdemeanor information or regular information or misdemeanor complaint or something, and then you could say the rest because I don't remember the rest.
Okay, I'll read it from the book. At the conclusion of the hearing, wait, which hearing are we talking about?
Felony hearing, the felony hearing.
Oh, at the conclusion of the felony hearing, the court must dispose of the felony complaint as follows. If there is reasonable cause to believe that the defendant did commit the felony, the court must hold him for the action of the grand jury. If not reasonable cause to believe that the defendant committed a felony, but reasonable cause to believe he committed an offense other than a felony, the court may reduce the charge. If reasonable cause to believe the defendant committed a felony in addition to the non-felony, the court may reduce the charge to the non-felony. Interest of justice and the DA has to consent, and it can't be a Class A felony. And if not reasonable cause to believe that the defendant committed any offense, the court must dismiss the felony complaint, discharge him from custody, and exonerate his bail.
Perfect.
Okay. Upon application of the defendant held in custody pending a disposition of a felony complaint who has been confined for a period of more than blank
120 hours.
Or 144.
If there's a weekend or holiday.
Right. Without a disposition of the felony complaint or commencement of the hearing, the local criminal court must ROR unless failure to dispose of the felony complaint was whose request?
Defendant's request. Consent.
Or prior to the defendant's application, blank files a written certification.
The district attorney files a certification saying an indictment's been voted.
Or indictment or direction to file a blank was filed
Prosecutor's
by the
information.
Right. And court is satisfied people have shown good cause he shouldn't be released. 16. After arraignment upon a felony complaint, except for which criminal charge?
Class A felony.
No.
Wait, well, I don't know what we're doing.
I guess it is a Class A felony, but it says 3 specific felonies.
Oh.
After arraignment upon a felony complaint, except for manslaughter, murder, and homicide.
Oh, you know what? We have this in my other video when I was at your house.
Either party, local criminal court or superior court may move for an order.
Terminating prosecution.
Yes. So you can't terminate prosecution for manslaughter, murder, or homicide.
Right, and you can't do it until a year goes by.
I guess I'm coming up to that. A motion to terminate prosecution may only be made where counts in a felony complaint have or have not been presented to the grand jury.
Have not.
Motion to terminate prosecution of felony complaint shall be in writing in where? The local criminal court, the superior court, or the appellate term?
It's in the local criminal court or superior court.
Right. The motion to terminate the felony complaint shall be in writing in the local criminal court or superior court. And the motion to terminate the prosecution shall not be made earlier than blank following the arraignment.
It's either 12 months or 1 year.
It's 12 months. We have a star next to this next one.
Okay.
Upon filing the motion to terminate the prosecution, the court shall make a return date and provide the parties with at least how many days written notice? Fuck, I can't remember.
Is it 5 days? It must have been something stupid if we couldn't remember it.
30 days.
30 days, shit.
I'm going to make a video on this because I can't remember that. A party that is given written notice of the motion to terminate prosecution shall be deemed to consent to such termination if they do not what?
Oppose it.
Right. And where the parties consent, where neither party files an opposition, the court shall enter the order terminating the prosecution on the return date. But if opposition to the motion is filed, the court on the return date shall enter an order denying the motion to terminate prosecution. But where the people file the opposition, the court on the return date may defer disposition for how many days?
60.
No, 45.
Fuck!
Remember the 45 days?
Oh my God! Can we do this question again?
Yes, but let's finish the last
All
part,
right.
and then we'll do the whole thing from beginning. There's one more part.
Okay.
If the court defers disposition of the motion for 45 days, and the counts are not presented to the grand jury or disposed within those 45 days, the court, upon expiration, shall enter an order terminating prosecution, unless within those 45 days, the people on at least how many days' notice?
10.
5 days.
There's the 5 days, son of a bitch.
And counts are not presented to the grand jury, that the court, upon expiration, shall enter an order. I'm sorry, I'm reading the wrong part. Unless within those 45 days, the people on at least 5 days' notice to the defendant show good cause for failure why they didn't dispose of those counts, or if such good cause is shown, the court, upon expiration of 5 days, shall enter an order denying the motion to terminate. So I'm going to go over that. So, are you recording me?
Yes, I'm recording, and I'm gonna say just all the time rules in this section, and then
the time rule.
And then you read the whole thing. So it's the 12 months, then a 30 days.
The motion to terminate is not earlier than 12 months following the arraignment.
Then there's a 30 days.
The court is going to make a return date. And he's got to give notice for that return date. And he's got to give them a 30-day written notice.
And then there's a 45 days.
And then what's going to happen is the court's going to give them the notice, that 30-day written notice. And if nobody files opposition in that 30 days on the return date, they're going to put an order. He's going to do an order terminating prosecution. And it's done. But if somebody files opposition...
If the people file opposition.
Well, if the defendant files opposition, they're going to deny the motion to terminate. But why would the defendant file opposition?
Maybe he's like, I'm not guilty, prove it.
Oh, because it does specifically say, if opposition to the motion is filed, the court on the return date shall enter an order denying the motion to terminate. And then it says, but where the people file the opposition, the court on the return date may defer the disposition for how many days?
45 days.
Right. And if the court defers it for the 45 days and they're not presented to the grand jury or disposed, on the expiration of that 45 days, they're going to terminate the prosecution. Unless within the 45 days, on at least 5 days' notice to the defendant, they show good cause for failure to present them or dispose them. And if such good cause is shown, the court, upon expiration of the 45 days, shall enter an order denying the motion to terminate prosecution.
And then it says that the court may stay sealing for a period not to exceed 30 days to permit the people an opportunity to pursue an indictment.
Oh, I didn't know that one.
Yeah, so this rule here, this is terminate prosecution. The time rules are 12 months, 30 days, 45 days, 5 days, and then another 30 days.
Holy shit. All right. Moving on. That was the last question on 80.
Woo!
180.
All right, so this video's done. I'm going to stop it.